Welcome back today. I'm Dr. Stephanie Holmes, and you might be hearing this on one of two platforms. You might be joining us through Autism Spectrum Resources for Marriage and Family or Converge Autism Radio, both brought to you by Mental Health News Radio. I'm very excited about my guest because I had to do a lot of research and understand some things I didn't know about myself. But our guest here is Martin Chen. Welcome, Martin, to the show.
Hi, glad to be here.
All right. Well, let me tell you a little bit about Martin. He got his BA from Vanderbilt University, his JD from Georgia State University College of Law. He has over 30 plus years with the U.S. Department of Education, Office for Civil Rights, ensured that recipients of federal financial assistance from the Educational Department complied with civil rights laws, which prohibit discrimination on the basis of race, color, national origin, sex, age, disability, and equal access, even with the Boy Scouts of America. So he is a resident of the Metropolitan area, which is how I have met Martin, as I also live here in the Metropolitan area. And he also attended Dekalb County Public Schools. So you're kind of native to this area, and then you're still in the area.
Yes, absolutely. Did not go very far at all. All right. So the first thing is I have to give the disclaimer. I am retired, and the opinions that I am about to offer are not the official position of the U.S. Department of Education at all. It is myself as a private citizen. And so let's not say the U.S. Department of Education says this or the U.S. Department of Education says that.
That was a very a lawyery thing to do. So thank you for your disclaimer as we start out. When Dan was telling me about your position, being in the advocacy field, going through all that we went through with our daughter and her education, I had no idea that your position, your previous position, even existed. So can we start with what you used to do with the U.S. Department of Education?
Sure. Okay. Yes. So what we did was we enforced civil rights laws. And when a school district, or in this case, LEA, local educational agency, agrees to receive federal funding, they agree not to discriminate on any of those bases that you mentioned earlier, those civil rights laws. And one of those, our primary role, not primary role, but the largest part of our job was dealing with disability, particularly students with disability, whether or not they were getting what was required under the law. Now, we dealt with Section 504 of the Rehabilitation Act and the Americans with Disabilities Act, but a lot of the students, as you and the audience well know, are dealing with kindergarten through 21, basically primary and secondary education. That does not mean that our work did not span into postgraduate fellowships even, or pre-K programs. So we did not deal with special education, but we touched on special education through the anti-discrimination laws regarding disability. So we would investigate complaints of discrimination based on disability. So the way that we got involved usually is that the IEP was not enforced. The IEP, the school district failed to implement what was required in the IEP, and that's primarily, that is the bread and butter type of allegation. We also dealt with accessibility. We also dealt with related aids and services, things of those nature. Now, whether or not something was whether or not the IEP was sufficient, that is not something that we dealt with. That's an educational decision issue. So we did not deal with educational decision issues. We dealt with whether or not discrimination has occurred on the basis of disability. So that's the difference. And then if you have a problem with an IEP, then that would be, you would need to go to the state. Well, first of all, you work it out with the local educational agency, and then you can go into the state and possibly even filing a due process hearing request. So I hope that answered your question.
Yeah. So I think this is going to be a very general thing, but if I do misrepresent any facts, please correct that.
Mm-hmm.
But so essentially, each of the 50 states, like they are still governed their own bodies, right? They're not controlled by the federal department. However, up until the 1970s, when that first act, the Education for All Handicapped Children Act, which I think was 1974, up until 1974, an LEA representative, an administrator, a headmaster could refuse a child with a disability to the school and just say, our school can't really handle your disabilities. So the the federal government couldn't really come in and dictate what 50 states did, but when they devised the U.S. Department of Education, the federal funds, if you want your federal funds to your school system, you must follow civil rights, ADA, you must be following the law. Is that like a generic description?
Okay, so actually the Rehabilitation Act of 1973, Section 504, actually predates the EHA, or which is now the IDEA. That was passed in 1973. So since 1973, there has been protection for students with disability, not just students with disabilities, but persons with disabilities that were receiving federal funds. So the Education Department has been, has been doling out money for education since the 60s, and so the Rehabilitation Act preceded the IDEA, which meant that we started enforcing that even before special education laws had been put in place, for example. So because the IDEA, which is a different part, is a different act. So the civil rights laws are under a different title of the U.S. codes. I don't know. It's one is a enforcement mechanism. The other one is a funding mechanism. I don't know if that makes sense.
Yeah, so absolutely.
Okay. All right. So that's where the difference is. But the way that a school district could come into compliance with Section 504 or the Americans with Disabilities Act is by using the scheme that is set forth in the IDEA. If that makes sense.
Yes. So when so people sometimes ask, like, what's the difference between a 504 and an IEP, or individualized education plan? The 504, to my understanding, comes from that Section 504, which is a civil rights issue, and the IEP is more of ADA disability accommodations, and they have different purposes for if you have a 504 versus an IEP. Is that correct?
Okay, so this is the way I like to explain it is Venn diagrams. If you know what Venn diagram is,
right?
Okay, the big circle. So the big circle is Section 504, and within that big circle is IDEA. So in order for a student to receive services under IDEA, he or she has to fall within one of the 13 categories that's delineated in the IDEA. Now, but it doesn't mean that and so that's one, and the way that the law is written is that, there has to be substantial impairment to a major life activity to qualify under the protection of Section 504. So If it does, if it is not a substantial, I mean, even if a student does not fall under any of the 13 categories, even OHI, which is the catch-all, then the student can be eligible for a Section 504 plan. Now, the thing is that with a Section 504 plan, you do not have the same, you may not have the same level of services that you would get under IDEA. Now, you still can. And then the other thing is, like, there are some parents that do not like the stigma of having a child in special education. So they would rather have a Section 504 plan. But a Section 504 plan still has to meet the requirements, the due process requirements. You have identification, evaluation, and then all the parental consents that's required under IDEA.
So autism is one of those 13 categories. The majority of people listening to one of these two platforms probably has a child with a developmental disability or delay. Correct. So that does qualify in the 13. Okay, so here's where parents get confused because just because a child has a diagnosis, ADHD or autism, doesn't mean necessarily they're going to get a 504 or IEP. So will you kind of talk about, so diagnosis is important. Obviously, that's something that's established. But what is the basis of the school's rationale or the law's rationale of when that person with the diagnosis needs a 504 or an IEP?
Okay. So the first step is identification. School districts are required under something called a child find. And that means that they have to take the affirmative action of going and inquiring parents whether or not a student is a person with a disability. All right. Now, who can be referred for special education or actually referred for an evaluation? It could be a parent, it could be a guardian, it could be a teacher, administrator, it could even be the student, him or herself. I mean, it doesn't. So the first step is identification, and so when that's done, then the first step is getting the parental consent. So the parent will need to sign off for evaluation. Now, there is a time limit. Usually, under Section 504, it's only reasonable, but under IDEA, it's 60 days. So it's 60 days from the date of the parental consent until the date the evaluation is completed. That's a time frame right there. All right. And then so after identification and evaluation, then the team would meet together. Both IDEA and Section 504 requires a team of people who are knowledgeable about the student. And then the thing is, like, during the evaluation process, they would have to use instruments. You don't use for a whisk or a rat or something like that to measure, whether or not a student is developmentally delayed, or it has to be, it cannot be something that is completely unrelated to to what is being measured. All right. So after the evaluation, then they will meet, and then they will discuss whether or not a child is eligible or not under one of the 13 categories. And then, and only then, they can propose the services that will be provided to the student to actually address those shortcomings. And the parent or guardian will have to sign off on that before any service can be provided to the student. Now, the delay, I think a lot of parent and guardians have, that they're frustrated with is the evaluation process, because there are certain things, particularly for a very young student, a lot of the instruments may not be appropriate for a student who cannot read. So and things like that, or if there's a compounding disability, English as a second language student, things of those nature. There are ways around it, but the main thing is that these folks want to get it right. They don't want to. So the evaluation process can be, frustrating for them. So
right. So some things I'm hearing you say that are really important are, once this happens, it can't just simply be the school psychologist or teachers saying, well, we've met with Johnny, we've observed him in class a little bit, we don't think he meets qualifications. So part of that should be happening in this evaluation are actually measurements of some kind that are meant to measure learning or ADHD or autism. You can't just say, based on our observations of Johnny in class, we don't think he has a problem.
Right. It cannot be something that's cursory. You have to have data. And classroom observations, that's fine, but you need to have some type of objective criteria, and that's where the evaluation instruments come in.
Okay, so something that might often happen in some of the clients I have dealt with is maybe they wanted to start the process and they wanted to start the child find. Maybe a pediatrician or someone at their place of worship says, hey, something's going on with Johnny or Sally here. Have you ever thought this or that? And so then the parents go, well, it does really take a long time to do homework, or there's a lot of refusal behaviors around homework. Maybe it isn't just defiant behavior. Maybe there is something going on. So they go to the school and say, hey, I want to start this process. My pediatrician or another teacher has said, hey, there's some issues here. I'd like to start this process. I'd like to have an evaluation. Can the school say, no, we're not going to do the evaluation based on, we don't think there's enough evidence to do an evaluation. We totally refuse to even do an evaluation. Is that possible or legal?
The short answer is no.
Okay.
No. There has to be some rational basis. There are plenty of kids with disabilities that have learned to compensate and are doing very well in school, and they're just super geniuses. But the thing is that they do have, they might have a disability. They may have learned to cope with certain things. But later on in the higher grades, that's going to hurt them. And they may not be able to compensate any longer. So the school district cannot, the LEA cannot just flat out say no at all. So if they do say that, the main thing, the thing that you want to do is you want to just go ahead and say, please give me my due process rights. Or you can contact if it's a larger school district and they have a Section 504 coordinator, special education coordinator, contact that office and ask to speak to somebody in that office, or work with somebody at the school district. Most schools have a Section 504 coordinator or a special education coordinator at the school level, and if they don't, then bump it up to the district level. But the main thing is to work with the school district first, and if you have to file for due process, that makes it much more difficult. To me, that is probably like the nuclear option. Because that means that no one is listening to you at all. So you do not want to do that as your very first step. Yes, you have the right to do so, but once you do that, it becomes an adversarial process.
Yeah, so we'll get to due process in a moment. So we're kind of walking through our steps. Okay, so I have gone and I say, I want to have this. This school has said no. We don't see a reason. We observe Johnny. It's not a problem. You can go to the county office. Okay, so now let's say the testing has been done. They actually use something like the WISC, the RAT, the Woodcock-Johnson, or something like that. And based on the scores, they don't see what the parents are seeing. This is what our data suggest. And the parents say, okay, we hear what you're saying, but we don't think you really captured what's going on. We would like to have an independent education evaluation. So they go to a developmental psychologist or somebody who is a legit person who runs a full psych eval, runs some of the same tests, has different interpretations of the data presented. And now maybe there was a diagnosis, a learning disability, autism, ADHD. So there's a piece of paper now, and the parents are having to say, hey, we want to meet again with the school. We have our own IEE and we want to discuss that. But the school says, we're not taking the IEE into consideration. We've done our thing. We've kind of followed the law. We are not taking the IEE into consideration. Right? Is there a problem there?
The short answer is it depends. A parent or guardian is given the opportunity for an IEE. Now, it very well could be not just any psychologist will qualify. The school district may have a list of independent psychologists that they recognize or that they've worked with, and consequently, you can pick a evaluation from one of the psychologists on that list. So, can they just flat out and say no? We're not going to consider anything from an outside psychologist. No, they cannot say that. I mean, they have to consider it. Now, does it mean that they have to adopt it? No, not necessarily. And not if there's enough, whether or not, based on, it can be, depends on if it's somebody from their approved list and it comes back and it's like, hey, this is what the psychologist found. Then it becomes a battle of the experts. The school approved psychologist and the school psychologist. So it's becomes a battle of the experts, and then you go back and forth, and then you can escalate it. You can go through mediation, or you can just say, hey, how about let's just try doing something here. How about let's try some intervention strategies? How about let's go with a 504 plan and see whether or not it addresses these particular problems. So the main thing, like I said, is to try to work it out with the school district first. I found that most educators they're not there to fight the parents. They want the same thing as the parents, which is to basically educate a student and have that child succeed. I don't think anybody gets into education for the pay. They deep down they do want students to succeed. Yeah. And I think that's where everybody has to come from.
So you answered a question so this is 20 years out, so you don't have to worry about anybody trying to get anybody in trouble, because it's 20 years ago. So when our daughter went through her evaluation and I was insisting that she was possibly on the autism spectrum, they said, we will only take an evaluation of autism from this one place. If this one place says that she is on the spectrum, we will say, yes, she's on the spectrum. But if they say no, we are not going to enter that into the data. So that was completely within their purview to say, we only work with this one entity for autism spectrum diagnoses?
That would be, that is a bit harsh, but they are entitled to say that. Now, does that mean that they're prevented from working with your daughter? Let's just take her as an example. The thing is that yes, we can observe and see whether or not there's anything, and this is where a Section 504 plan would come in, because okay, so yes, I mean, if let's say, for example, it was the Marcus Center, or something. I think that's like the preeminent.
In the Metro Atlanta area, most people know the Marcus Autism Center.
Yeah, exactly. Yep. So, I mean, let's say that, hey, we only work in Marcus Center or something like that. Then it's like, okay, well, fine, but I think we should do this, or could we do this? Can we, make sure that we give her extra time on certain things, or that we don't necessarily have to have her present in class or something. I mean, whatever works, and just work through the particular things that you're asking for, and see if the school district can meet you. Meet you there, and then there are instruments, and just like hey, how about let's observe her for say the next 90 days or so, and then we can meet again and discuss it some more.
Okay, so now let's say we've gotten to the process. We've been through all these steps, which for the parent, having been on that side, is very frustrating because 60 days, 90 days, and we're almost through a semester. Saying we started this in August, we are almost through the first semester by the time this is happening. But let's say we finally are in January and we are sitting down and we have come to some conclusion about an IEP. We actually have a signed document that these are the accommodations and these are the things we're going to do. So your office had nothing to do with the decisions being made, but now there is a document in place. And let's say after a couple of months, the parents are not seeing these accommodations and modifications put into place according to the IEP plan. So I'm hearing you say, first of all, you want to try to work it out with your teacher, your LEA, your local education agency, and then maybe you have to escalate that to the county 504 coordinator. But if the school or your district still is not wanting to implement it with fidelity, or is doing half but not the other half, or makes a unilateral decision. So I'll just give a real example. So in our daughter's case, she had a para, and the school decided about in October or November, she no longer needed a para. So she had it. It's in her IEP. She's supposed to have a para with her every day. The school decides, you know what, we think the para is a crutch. So without collaboration with me and without collaboration with a lead teacher, say, we're going to start using this para as a TA. And if Sydney needs her para, we'll send the para back. So to me, that doesn't feel like a following of the IEP. So if that was someone's situation where they're like, hey, this isn't being followed, we didn't have a discussion about this, you can't make a unilateral decision about removal of a para, and the school doesn't want to cooperate. You've done everything that you can, and you have to escalate to due process. Now, what does that look like? What does that process entail? Because I was talked out of doing due process because they were saying, oh, you're going to have to get a lawyer. It's just going to be so expensive. This could take so long. It could cost you $5,000 to $10,000. In the end, it's not really a court. It's all educators. They're on the court. It's stacked against you. You really don't want to do that. So I was like, well, yeah, that doesn't sound like something I want to do. So how is due process supposed to work?
Okay. All right. So So if IEP is not being implemented with fidelity, I like to think of IEP as a contract. Basically, it's a contract between you and the school about your child. So if the terms of the contract are not met, then you can give them the opportunity to address it. they choose not to, or they just they fail to do so, then you can file a complaint with the state. And that is just basically a discrimination complaint, or with my former federal agency, the Office for Civil Rights. Those are free, and they do not require attorneys at all. You file a complaint. I mean, you can do it online, and they will send somebody out. And within 180 days, once again, I know 180 days is a very long time.
Where?
I know exactly. Within 180 days, they will. Both those agencies are required to issue a findings. Usually, it's quicker because I mean, once a school district gets a complaint, they will want to sit down with you and then talk it over. Because the thing is that in a good IEP, there will be progress reports that are sent back to the parent on a regular basis. So you will know exactly whether or not the parent was with Sydney for the entire day or not. They were, if they did, I find it hard to believe that they were just playing. That would be stupid enough to tell you, oh, we're not. Her one-on-one aid is not going to be, necessary for her anymore without consulting you first, because that is absolutely. I don't know.
Well, Martin, this is the same school that required Dan or I to come to school with her, or she was not allowed to come to school.
I know. I don't understand that at all. Because that I hope
she doesn't need a para, but one of you parents better be here.
Well, I don't understand. I mean, that's not the school district is not doing their job on that one. And I'm sorry that that happened to you, because parents should not be put in that kind of position at all. And that's why there are these laws that are in place to make sure that the school districts do right by the student.
So when in filing that complaint, that is when your office would get involved. So
Correct.
A parent says, I'm not ready to go to due process yet, but I need to send the school a message that this is not okay. The IEP is not being followed with fidelity. I've tried to be reasonable. I've tried to have appointments, and I'm just getting blown off. I'm just being told everything's okay. I just have to trust them. So in our case, how we found out was my daughter was telling me her teacher, her para's name wasn't with me today. And I was like, oh, maybe they're sick, a benefit of the doubt. Maybe they're sick, she's a parent, blah, blah, blah. And then it's like, well, she's not here either. Or I see her, she's on campus. She's helping so-and-so's class as a TA. And so it's like, So again, I have a third grader. I'm not just going to believe a third grader, but, do some investigation and find that to be true. So at that point, you're saying I could have filed a discrimination complaint.
Yep.
And that's when your office would come in and maybe help, because the hope is maybe that gets the school district's attention. And because we're trying not to go the nuclear option of due process.
Yeah. That's precisely it. And then due process, due process does not require an attorney. I mean, there are plenty of lay people that go to due process and take it, and win. The thing is that once the school board attorney gets involved, they know what's, they'll look at it objectively, and they will see that, okay, the school district here was clearly at fault by pulling the para away from your daughter. I mean, that's just, that is just beyond stupid. And their job is to be objective and make sure that the school board is not subjected to, any more legal liability than, not to be subjected to legal liability for something that is so easily remedied.
So once you go to due process, this was another part that was really confusing to me as a parent
Mhm.
because it doesn't sound like due process is, I don't mean to be disrespectful, but like it's not a real court with a judge and jury of your peers. It's a different system.
It is
Correct?
actually there is a hearing officer. And the hearing officer is from the state, at least in the state of Georgia. It could be different in other states. Um, they, the hearing officer is an attorney. There are specific time frames you have to meet. Basically, you have to, and there's discovery as well. So it is operated. I mean, the closest thing to be I can analogize it with would be arbitration. Basically, you don't think arbitration as being like real court, but arbitration, binding arbitration is final. And same thing with due process. Due process the decisions are, I mean, they're final, but they can be appealed. But the thing is that once it's appealed, it's very unlikely that it will be reversed. So due process. You might think that it's not a fair fight because this, especially if you don't have an attorney. But if you read the laws, if you do all the legwork, and I mean, you just basically follow the checklist. There's nothing preventing a parent from doing it him or herself.
So with arbitration, for those who may not know arbitration, essentially then it's like the two sides are presenting the information and data, and the hearing officer or whoever is presiding, the judge, then makes a decision based on. So it's not back and forth and cross-examination. It's not like what you're thinking a courtroom scenario is. It's here's the data, both sides, and then whatever the person says, that is it. That's the final decision.
So yeah, a due process hearing is binding, okay, and so the hearing officer makes a decision, and it can be appealed. So depending on the rules, and it is actually it's much more informal. However, the evidence. I mean, there are. I mean, you can present witnesses. You can bring witnesses. You ask questions of the witnesses, and so it's not unlike court, but it is a much more informal way of. It's not as long of a process as a court proceeding, which could take years. Due process is done relatively quickly, within a few months or so.
I think what feels scary to the parent is, like you said, when you go due process, things get very adversarial. Yet my child is still in this situation and in this school system.
Correct.
While this is happening, we're adversarial now. And especially in our case, since there actually was some abuse going on with our child, it's like, do you really want to set your child up who's already in a physically unsafe space?
Yeah.
While you're in and until you're waiting for someone else to say it's physically unsafe, that seems like that. And that was certainly a deterrent for us. Like, we're just going to move states. Like, forget about it. We're not going to go that. We'll just completely move out of this district and move to Georgia, at this point, and to do our due diligence on where we're going to find a school with administrators and people who really understand autism, which Asperger's at the time. So that's our choice, which not a lot of people can make, right? There's resources and moving.
Right, precisely. Yes.
But I guess that becomes a problem to the parent. But then there's this other issue of it's talked about, but I don't think people understand it's not as easy as someone thinks. So I've had people say to me, I've got this IEP. I don't think the school's really handling it well. And I'm going to use my, state credits or whatever. And I'm going to get the state to pay for my child to go to private school who is will help this child with disability. Talk about that process, because I've never seen it be a fast, easy thing. And then based on what the IEP is how much money or funds that they might get allotted. So can you talk about that process?
Okay, so the state of Georgia has something called SB 10. I think the SB 10 is the Senate bill. that created that particular scholarship. And then Florida has something called the McKay Scholarship. And then they both work the same way. The money is actually it's based on private contribution to this separate trust fund that's administered by the state, and there's no federal money involved. So it falls outside the purview of Section 504 in the Americans with Disabilities Act and the IDEA. So the thing is that, and because because it falls outside of that purview, you don't have the same protection. All right, so that's one thing. And the amount of money that you will receive is based on the intensity of services. So there's a matrix that's involved with the application. And so the application, you fill out your part, and then you get it to the school, and the school will tick off what services a student receives. So the more related aids and services a student gets, then that there's more points for that the IEP is worth. So then that child would get 100% of the funding for that particular scholarship. Let's say for the SB 10. Now the thing is that these are not infinite, pools of money. It's finite. And so the thing is that you have to apply early and certainly before the deadline, and then make sure everything is in, and then you will get it. Then you can take it to a school of your choice. Now, that school, you may not get all the IEP services that you had gotten with the public school. Another thing is that you must have been enrolled in a public school for at least one full year under SB 10. So if you were not enrolled in public school, you are not eligible for the SB 10. You cannot say, my first year in school, I'm going to apply for the SB 10.
So it also seems like that excludes homeschooling students as well, then.
Yes. I mean, unless the school district offers IEP services. Let's say that there's OT and PT. I mean, it does not necessarily exclude them. I mean, there's OT, PT, speech therapy, whatever other services that is being provided outside of homeschooling or even virtual school, right? I mean, virtual school can be somewhat analogous to homeschooling because it's not inside a school district per se. So the amount of the money is going to be based on the intensity of the services and how many points. That particular school, like I said, is not required to provide all those services. And it could be a sectarian school, or a religious school. It doesn't matter. But you are giving up some of your rights under the IDEA in Section 504 once you go that route.
So this might be simplistic, but if I'm trying to think like those who might be listening. So let's say, all right, I have my IEP. I don't feel like it's being done with fidelity. I'm going to try a special school. So I'm going to be generous and say there could be a range of tuition for like $20,000 to $40,000 a year for one of these kind of special schools. And then we kind of start this process. I take my IEP, and based on the services my daughter's receiving, like a para might be worth a certain amount of points versus extra time on test and quizzes or something. So there's some kind of point matrix. And then whatever that is, that still might only net me $10,000 or $15,000 in credits or whatever towards this school. It's not like, some parents get really confused. It's like, well, I've got an IEP. I can just take this and, get this funding, and I'm going to get $40,000 in tuition for free at this school because I'm going to use this thing. So there's there's some system that says whatever you're receiving in your IEP is worth a certain amount of funding you may be eligible for, but it's finite, meaning if they've only got $100,000 in donation or something, that might only be a few students, and that organization with their pots of money gets to make that decision. Is that correct?
Well, I mean, it's like a full award is not going to be anywhere close to pay. Let's say, okay, so for example, there are a few schools in Atlanta that are very, very good at dealing with learning disabilities. The Skank School is phenomenal. Skank School is not cheap at all. You will not be able to go to the Skank School for free on an SB10. Plain and simple. You're not going to be able, that's not going to happen. You're not even going to be able to get to Howard School on the SB10 and get a full ride. It is depending on what level of services your child gets. It may not come anywhere close to what the private school can offer. And like I said earlier, you have no recourse. Basically, once you make that decision, you're outside the protection of Section 504 in the IDEA and the Americans with Disabilities Act.
Right. I was an educator once at a parochial school, and even if we identified someone, like I would always push for them to get services and accommodations, but it's it's essentially a handshake between the school and the family. Like, hey, we're noticing your child maybe could use a little bit of extra time on tests and quizzes. We'll kind of throw that in and see if we want to do it. But if we don't want to do it, I mean, you really can't make us do it either. Like, we're willing to try, but we don't really have to stick to that. There's no legal bindingness to the parochial or private school saying, okay, we're going to try or do this. It's not as binding as the IEP, correct?
Absolutely. Yeah. I mean, that's exactly right.
So, the last thing I wanted to talk about, when you and I were kind of talking about this phone call, you said that in addition to your work with the U.S. Department of Education, you also kind of on the side used to kind of use some trainings or workshops for lawyers. And that was of interest to me. So can you tell me about what you kind of used to do? And if there is maybe a lawyer listening that says, hey, I kind of want to retool or learn that, talk a little bit about what you used to do on the side.
Okay. So it wasn't on the side.
Okay.
It was an approved activity from the U.S. Department of Education.
Okay.
So no.
I love interviewing lawyers. So yes.
No, absolutely. No, I did not know. We were it was very specific as to what we can do and cannot do. All right. So this was a initiative from the Younger Lawyers section many, many years ago. For a number of years, what we did was that I was part of I was the co-chair of the committee that trained lawyers to help parents. It was the Advocates for Special Needs Children Committee of the Younger Lawyers section of the State Bar of Georgia. That's a mouthful right there. So basically, it was a number of lawyers who agreed to represent parents with special needs children, and the way because there were a number of, well, first of all, there aren't that many lawyers who actually do that type of work. And then for another part was there weren't that many lawyers statewide that did that type of work. So consequently, we did this. We trained the lawyers. We gave them, it was basically a one-day crash course on how to, basically Section 504 and the IDEA, Americans with Disabilities Act, familiarize them with the alphabet. All the acronyms, so that way they can at least be able to speak intelligently on these things. And then in exchange for this, they agreed to take on a certain number of cases. This lasted about maybe 5 years or so. And then after I aged out of the younger lawyer section, no one else took it over. There was a referral service that through the State Bar of Georgia you would call up, and then they depending on your geographical area, the State Bar would refer you to a particular lawyer within that part, that could speak to the parent and help them out regarding special education issues. So that has gone away, which is unfortunate. But and I feel awful because after my kids came along, I didn't have as much time to help out and lead this project. But it was a good project while it lasted, but it probably ceased somewhere in the late 1990s, early 2000s, and that was it. So it hasn't been in existence since then.
For us, quite some time. So if there was someone in the field of law who was, hears this and is like, this sounds like a difficult process for families, and I am interested in learning more about that since this doesn't exist anymore, specifically in our state, how does a person, what would they do then to become educated or want to become a lawyer in this field?
Well, I mean, there are a few lawyers who are very, very good at with special education law. One of them is Perry Zirkel, Zirkel. He's at Lehigh University. He's excellent. And then within the state of Georgia, Jonathan Zimring, Zimring. He was one of the first ones that did special education law. Torrin Togut, Togut. Torrin has been doing this for a number of years as well. He was with Georgia Legal Services for a number of years. I don't know if he's, but those are some names that they can, if they want to contact them. But the internet is very, very good. And then you can, the first place to look at is actually just go to the, giving my former employers a plug, the U.S. Department of Education, go to the website and read there's a reading room there on the OCR section of it. And it's ed.gov/OCR. And go in the reading room and you can read by the particular topics. So disability is one thing that they can read. Now, there's one thing that I do want to point out, and that is, autism was even as recently as 2015, 2016. I'm going to put on my reading glasses here. Was approximately 8.9. Let's see, I want to make sure I get the number correct. Okay, so in the state of Georgia, autism was 8.9% of all the students who have been identified with disability. And then most recently, let's see here, in fiscal year 23, which started, I believe, on July 1st of this year. Autism now represents 12.68% of students with disability. So, I mean, that has grown, and that is a trend, and I would imagine that it's probably going to go up more. And so, I think that I hope that parents do take the time to educate themselves, because they're the most effective advocates out there for their kids' education. So I commend you for doing the homework and getting things done for your child, and then now you're helping out other parents. So thank you for that.
Thank you so much for being on the show. Yeah, a movement I would love to see is following something I've been following in England, which is all teachers are required to have some kind of training on autism, because if we're going to try to do the least restricted environment, many people who are high functioning or used to be called Asperger's or autism level 1 can usually do the work of a mainstream classroom. There are just other supports that are needed. So the likelihood that a mainstream teacher is going to have a child with autism in their classroom is very, very high in their teaching career. So I would love to see at some point some training for all teachers on that, but I don't make those decisions. But listeners, if you're interested in my research, you can look me up, Dr. Stephanie C. Holmes. I have 4 published articles on creating an inclusive environment for students on the autism spectrum based on special education law, not just based on our specific situation with our daughter. My daughter's situation made me want to do the research with other parents to see what else is going on out there in the public school system. So look my name up under Google Scholar and you can find some of those articles. Well, thank you so much for being here, Martin. You have given a lot of good information, dispelled some myths, given some facts. Any last takeaway for parents maybe in this struggle?
I hate to say this, but there is really no quick fix and quick answer. So it's arduous and it's torturous, but do know that there are people out there that are willing to help, and a lot of those folks are in your schools. Those particular folks you reach out to them. You'll find them to be great resources.
It's a process. Well, thank you again for being on. And we always like to remind you listeners, there is hope for your future. And we hope through this podcast, you realize you are not alone on this journey.